Hello, everyone. This is Gilbert Gelada. I'm talking to you here from Private Corporate Counsel, downtown Orlando. This is Tufts on Tax, where all your tax questions and answers are right here with Mr. T. Scott Tufts. When it comes to taxes and tax law and tax litigation, you can call him at 877-647-7887, or you can reach him at stufts@pcc.law. That's stufts@pcc.law. Hello, Scott. How are you?
Hey, good to be with you.
Good to be with you too today. We have a different subject as usual. Today we are tackling a topic: after years of going one way tax-wise, can I suddenly go the other way? What does that mean?
Okay, so as we look at the tax law, this happens quite often for folks that for many years, let's say the easiest example is for many years you are a partner in a partnership, and you get a K-1, right? We've talked about that.
Yeah.
And then let's say you've done that for 10 years, okay?
Okay.
10 years of it. You've been fine with it, okay? And the 11th year, or whatever year, you decide, I'm not a partner. Can you do that? How does that strike you?
I believe you can, but there are regulations on that.
Right. So would it seem okay to you if you're the tax, the IRS or the government or just policy, that if you went 10 years, going along with being a partner and getting the tax forms that are associated with being a partner, would you think it would be okay for you to show up in year 11 and try and argue that's not the case, that you're not a partner? And for whatever reason, would it strike you as inconsistent? How about that? How does the word inconsistent seem to you? So they come up with ideas that suggest that it's like a whipsaw issue. So what happens is parties will take inconsistent positions, and the government has to find a way to attack that. And the duty of consistency, or the idea that the government, you should not be allowed to do that, the government has a way to attack that if it applies. So they have a doctrine of consistency that will say that if you've gone along 10 years, right, in one way of treatment, right, the general rule will be you can't change things in year 11 for your benefit, right?
I see.
Because it harms the government, harms the interest. It doesn't seem right, should not be allowed to do it. So the case that has come out that caught my eye was the state of Fry. The citation to that for our audience is out of the tax court memo decision 2024-8. Came out in January, of 2024. And what happened there that was interesting is you had two companies who had relationship owned by the same owners, but they had monies going back and forth between the companies, and the accountants were keeping that straight, where these were two S corporations, and they were keeping who owed who on the books. They didn't have formal notes or anything like that, but they had it kept accounting-wise proper, meaning they kept it, who owed who, what, and for what purpose and all that. So the government came along, and when one of the companies went belly up, the question was a loss that had been claimed. The government challenged that taking of a loss on the idea that maybe these numbers didn't add up. And the reason why it came up with this doctrine of consistency was they, for years, had booked it as debt on the books. I owe you, you owe me, two companies owned by the same people. Got it? So the effort to classify something as debt or equity is another kind of thing, right? So when the government saw this, they said, wait a minute, you're now, because what happened was when they came to reporting the consequence of one of the companies going under, they, their taking of a loss, in this kind of fact pattern, they treated it as equity. So the government used the same concept and said, wait a minute, for years, you have booked it as a debt, right? But we do not believe you should now suddenly be able to classify it as equity and claim a loss. Okay? So, different categories, different things. Remember, I said partner, not a partner. Debt versus equity. Employee, independent contractor. We've dealt with this on so many different fronts.
Correct.
Shareholder, not a shareholder. Okay, for S corporation or otherwise. So you see what's going on? Very important classification issues. And so this case is interesting because it deals with debt or equity. And the government comes in and says, wait, hold on, right? You're claiming a constructive kind of dividend treatment that we think is personally not consistent with how you've reported it, correct? So what happens is if you've gone along years and said it's debt, you should be held to that. Was the government argument in this estate of Fry case? Okay, now the government, the IRS in this case argued that a duty of consistency or a doctrine of election should apply to prevent you from doing prevent the taxpayer from doing what they did in this case. Okay. And interestingly enough, the tax court held that those doctrines didn't apply under the facts of this case. So what have we said over and over and over again on this podcast? There's no always answer, right? You cannot say this is the rule, this is the way it always will be, don't look any further, and just go on about your business. Most of these situations with tax are much more complicated. You cannot have an easy, one rule fits every situation. It's going to be, it depends.
Of course not.
Okay. So, well, life, and I'd argue, of course, life is complicated.
Yeah.
Life isn't simple, right? Human body isn't simple. It's complicated. A tapestry of amazing things, maybe. And but the tax law, as we've talked about long ago, went from something simple to something complex, motivated by policy reasons and policy decisions of awarding some behavior, punishing other behavior, or at least not promoting certain behavior. Charitable deductions, mortgage interest, you name it. There's a motivation to promote certain behaviors. Medical expense deductions, we're going to give people a break on that. On and on and on. So the question becomes, when you get into these battles, what is the thing? And so if you didn't know about this case and you knew about what we had started to show, once you go one way, can you ever go back or go a different way? Here's a case where you could. They went years for reporting it as, quote, technically speaking, debt, okay, on the books, got it? But when it came to a tax situation, the taxpayer successfully argued that they could change and go and say, no, it really is equity, not debt, okay? And we're going to allow that treatment. Now, you might say, well, how could that be? And one of the things that's most interesting to me about the case is that they talk about how debt, classifying something as debt versus equity for tax purposes, is a substance over form analysis. And it requires it requires an analysis of factors. So I don't know if you remember, but when we talk about employee independent contractor and you're trying to figure out which way is it, you weigh factors. Actually, right. in the employee independent contractor context, we use a category, the government uses, or the IRS uses, for tax purposes, a categories of evidence approach that takes three groupings of factors and then weighs them in an analysis that does not include a presumption of employment. Okay? It's not like the ABC test. Well, those factors apply. But how do you know if you're right? You're weighing the factors. You hope if you have an advisor or a CPA lawyer that advises on these legal issues, that weighing the factors, who's analyzing the factors and then determining what the greater weight of those factors are in determining what the issue is. So what happens if for years you've gone along with a classification that is inconsistent with the way you really are, right? Well, so this is, you see where this is going? If it's a little bit murkier, maybe that makes a difference. But the Fry case tells us that the substance matters, right? And here's what I like. It's talking about, remember, we have two S corporations owned by one person. They're money moving back and forth. They're trying to keep track of that, and they book it on the books, accounting entries, net this way, net that way, whatever's going on, right? See what's going on? But they don't have a formal note. They don't have anything like that, okay? So my question to you is, if the particular jurisdiction you're in uses, and in this case was out of the Ninth Circuit, so they used 11 factors that would be relevant in determining whether something is debt or equity or contribution of capital, okay? Now, the test involves, now listen to this, here are 11 factors. The names given to the certificates evidencing the debt, okay? That means, what did you call it, right? What did you put it on the books as, right? The presence or absence of a fixed maturity date. That makes sense? If I said to you, I owe you money, right? But we don't say when, what do you think? See the difference?
Yeah.
Debt means debt, right? I owe you X amount. You'll pay me back by X. You'll pay me so much interest. Mm-hmm. Once we start to lose some of those things.
So that's not determined.
So let's go back. Let me just, before I get to the 11 factors, because I want you to get this. When you form a company, you capitalize a company. You know what that means? You invest in your own company, let's say, or in some company, and you put it at risk. What does that mean, Gilbert? Okay, I invest in the company. If it goes under, I've lost that money, correct? I don't loan it to my own company. I guess you can, but you have to have capital to run a business.
Absolutely.
How much? I'm going to loan $1 million to my own company for a startup, and I'm going to put $1 at risk. Does that sound right to you? Doesn't that seem thinly capitalized? Doesn't that seem a little odd? So when we say, are you going to capitalize your company? How much? Well, we know the answer is 0 won't work, correct? And $1 probably won't either, correct? All right, so if you follow where I'm going with this, you have capital, at-risk capital, okay? That is your ownership interest. This is why we have equity on a balance sheet, right? All right, now let's go a different way. Once I have equity and the company needs more money and I have partners and they're not willing to put up money or whatever the case may be, shouldn't I be allowed to make a loan to the company? Shouldn't I be allowed to decide whether the company and its other partners are good for it? Shouldn't I be allowed to determine and negotiate, is that a good loan to make? Shouldn't I then be able to put together a term that says we're going to treat it as a loan and put, repayment terms in there, right? So if you follow what I'm going at, you're starting to say, well, no, I really want to be a lender and an equity owner in that situation. Can you do that? Of course. But you see, if I'm negotiating with myself, who's going to drive the bargain? And if I'm loaning company and they can't pay it back, what am I doing? So let's look at the factors. The names given to the certificates evidencing the debt, the presence or absence of a fixed maturity date, the source of the payments, who's going to pay back the loan, right? Who's paying it? The right to enforce payments of principal and interest, whether the advances increase participation in management, whether the lender has status that is equal or inferior to regular creditors, the objective indicators of the party's intent, 8, whether the capital structure of the borrower is thin or adequate, and 9, the extent to which the funds advanced are proportional to the shareholders' capital interest. So Gilbert, if my loan is if we all put up the same loan, two of us are partners, and we both put up a 50% loan, it starts to look like capital. See how that? A factor. The extent to which interest payments come from dividend money. And number 11, the ability of the borrower to obtain loans from outside lending institutions. All right. So in other words, can you obtain loans from other sources? You know what that's testing for. If you couldn't borrow from anyone but your owner, might be really at-risk capital, correct? Because you can't get a loan from anyone. Got it? All right, so why am I going through all that? Because what happened here in Fry, and we'll finish this up, after going through the analysis of all these 11 factors, okay, what's interesting to me in this analysis is that the court comes down and says, there's no harm to the government in this particular situation based on the classification of the debt versus equity. All right? So they took in expert testimony and came to the conclusion, right, that in this context, there was no harm to the government simply by those accounting entries. In other words, there was no tax fallout, no kind of problem with it. Okay? So it was critical that the harm to the government not be something that is assumed in the analysis. Okay? And what they say is the courts have declined to apply a duty of consistency in cases where a taxpayer did not receive any benefit and the commissioner did not suffer any detriment. Interesting. Right? Interesting. And this gets into where people start to say, wait a minute, no harm, no foul? Harmless error? So anyway, and then the other thing the case talks about, and we'll finish up, is that the court, interestingly enough, looked at the doctrine of election, which is an equitable principle that generally precludes a taxpayer who makes a conscious election from revoking or amending that election without the consent of the commissioner. So, wow, you think about the context where that might apply. There's lots of elections in the tax law, so you better be careful about that when looking at trying to reverse elections. So many elections are reversible, but at least know the government can make an election. What they argued in this case was that the doctrine should not apply in this context because the transfers or the payments going back and forth, the court did not see that as a free choice or an election as such. It was a characterization based on factors that indicate the true economic substance of that transaction. Okay? So they were careful to say the doctrine of election, if it's going to come in, this is not the type of context that they are going to apply it. All right? Now, before you think it was a home run for the taxpayer, there were penalties assessed against the taxpayer in this situation. And so for what it's worth, the accuracy-related penalty was applied and found to have been properly applied. There's procedures that have to be adhered to. So they came in and applied the penalties and so forth. And then there's still calculations that have to get done. So the case, I'm careful not to say it's a taxpayer win, but one of the things because you have to calculate the impact of this decision, and there's number crunching that has to go on with the actual tax impact. But for our audience, I cannot emphasize enough that if you catch yourself applying a tax principle in a way that says this is the rule, this always will be the rule, there is no ifs, ands, buts about it, just make sure. Just make sure that you're not failing to see some new case law development or some issue that you didn't think through. And so Back to what? So what was the original question you asked me, Gilbert? Something about when you're going one way tax-wise, can you go reverse?
Yeah, it was after years of going one way tax-wise, can I suddenly go the other way?
So our answer from today is maybe. The answer isn't no and always no.
Yeah.
Right?
Correct.
So our audience needs to know that stay tuned, because this, you can see how when you have a case go against what is a general rule, what do we expect to happen? We expect our wonderful taxpayers out there to what? Argue that this case should always apply, right? And we might see partners who are been partners for 10 years argue, right? I'm going to reverse field and I'm going to argue that this Fry case gets me there. So what we're going to do is we'll hit other topics. But again, so audience, you got debt, equity, partner, non-partner, employee, independent contractor. Lots of these divides in the tax law where the characterization or the classification gets challenged. And if it's based on factors and you've got a situation, don't simply presume you're stuck. Get a look at it, see if there's any harm that was created to the government, and if there's no harm, or you think you can make that argument built on the kind of things that's in Fry, take a look at that and don't wait and see. We don't know. Maybe they'll appeal this case, so you always also have to be careful there that when a case like this comes out, we want to be careful that you see the latest lay of the land. Check out, appeal. Did it get reversed on appeal? Something like that as well. So
you heard him, folks. Be careful and always stay tuned. We're going to talk more about this and other subjects like this. You can call Mr. T. Scott Tufts at 877-647-7887. Again, that number is 877-647-7887. There's a 407 number as well. And you can reach him at stufts@pcc.law. That's stufts@pcc.law, or you can visit the website at privatecorporatecounsel.com. Thank you and have a wonderful day.